Friends, hello and welcome to another episode of The Legal Breakdown. This is Jason Sansone, and I'm happy to have you on another episode of our show. Like always, The Legal Breakdown airs every Wednesday from 5 to 5:30 on KTLV 1220 AM radio. In addition, the show can be watched on Facebook Live on the Sansone Hell webpage, and it's broadcast on YouTube.com and is a podcast on Google Play, Apple iTunes, and is in the Spotify directory. Before we jump right into today's episode, I want to take just a moment, though, to remember the founder and owner of KTLV 1220 AM radio, Mr. Howard Williams. Some of you may remember that we actually did an episode back in January with Howard when we were announcing the kickoff for this program. We spent a while talking about his time as a public servant. He was in the House of Representatives in Oklahoma for quite many years, but I must unfortunately share with all of our listeners that Howard passed away a few weeks ago in March. Fortunately, I can share that it was very peaceful and that he lived a very long, very prosperous life and leaves behind a great legacy in his family. But we want to let all of our listeners and our viewers know and just take a moment to remember Mr. Williams, what he's done for our state and what he's done for this radio station. Continuing on, today we're going to talk about mortgages and second mortgages in bankruptcy. The different chapters of bankruptcy, Chapter 7, Chapter 11, Chapter 13, can greatly affect the powers that you have and what you could do with a first or a second mortgage. So the first thing we need to try and touch on in understanding what your options are is that you have a huge difference between Chapter 7 and then Chapter 11 and 13 because there is no plan of reorganization. In a Chapter 7 case, you prepare and you file the case. You have liquidation. You're going to wipe out the debts that can be wiped out. You're going to be forced to sell non-exempt property. But we're not going to have the ability to alter or change relationships, those secured obligations, the contracts, like we might be able to do in a Chapter 13 or a Chapter 11 plan of reorganization. So that means you don't have what are known as cram down powers in a Chapter 7. What is a cram down? A cram down is when we can force a secured creditor to accept less than what the deal originally was. So let's say that you have a car. You owe $20,000 on it, and it's worth $10,000. You've checked Blue Book, you've checked NADA or KBB, it's worth $10,000. You're upside down, you're underwater. In a Chapter 7, other than possibly negotiating a reaffirmation agreement, you're going to be stuck paying what the vehicle is worth. In a Chapter 13, under certain circumstances, you could force the creditor to take that fair market value and a fair interest rate, and that's known as a till rate. In that particular instance, we have what's known as a 910-day rule. You can only cram down motor vehicles in a Chapter 13 if the vehicle was purchased more than 910 days prior to the filing of the bankruptcy. In a Chapter 11, that rule doesn't exist, but it's very unlikely that any of our listeners will be in a situation where they'd be using an individual Chapter 11, but it would be available. But we're not here to talk today about cars. We use that as an example. What we want to talk about are mortgages. Now, fortunately, these problems have become less prevalent in the last 10 years. But after 2008, it was very common to have first or second mortgages that were partially or wholly upside down, underwater, that there's not enough value in the home to equal the value of the mortgage. So then that gets to the important questions of, can you get rid of all or part of a second mortgage? Can you modify and get rid of all or part of a first mortgage? So those concepts are called strip down or strip off. If you get rid of a lien on something completely, that is to strip it off. You make it go away. If you strip down a lien, you're reducing the value of it. So let's use some real world numbers so that this makes sense. You have a home and it is worth $250,000. It's worth $250,000. Your first mortgage is $200,000. So it is fully secured. It is not what we call undersecured or undercollateralized. They would be able to get all of the value of that $200,000 loan against the $250,000 property. But then you have a second mortgage, and the second mortgage is $75,000. It is partially secured. It's not wholly unsecured, but it is not fully secured. $25,000 of it would not be recovered if the property sold for $250,000. So then the question is, are you stuck paying all of that $75,000? In a Chapter 7, the very unfortunate answer would be yes. In 1991, the United States Supreme Court ruled on a case. It was Dusnip v. Tim. Sorry, 1992. I said 91. And in that case, the issue was exactly this. It was known as strip down. Like I said, we're not yet discussing strip off. But the question was, if there is a partially secured lien, do you still have to pay for all of it? Or can it be reduced in part so that one half or portion of the lien is treated as unsecured and the other is treated secured? The Supreme Court ruled in that case, and is an often criticized case, but they ruled that you cannot do that. So in a Chapter 7, you cannot strip down that second mortgage on a property. You could do so in a Chapter 13, though. We could cram it down. So first scenario we've discussed is if you have a home mortgage and then you have a second mortgage, whether it's a line of credit or a true second mortgage, and it's not fully secured. You would be better to use a Chapter 13 under most scenarios to decrease the value of that mortgage because you could cram it down so that now what you owe is equal to what the home is worth. You could do the same in a Chapter 11. The next situation, the next scenario, is the issue of a complete strip off. So let's use some real world numbers before we talk about that. If you have a home and it is worth $250,000, $250,000, but you owe on a first mortgage $300,000, and you have a second mortgage for $50,000. If the home would sell, the first mortgage lender is undersecured. They would not receive all of their value. They would be left with $50,000 in debt because we would sell the home for $250,000. We would apply that to a $300,000 loan. $50,000 would remain, which means the second mortgage is also fully unsecured. That $50,000 mortgage would not receive any value at all. So in this situation, well, could we get rid of that second mortgage? Because it doesn't even have a penny of value. It's wholly unsecured. That would be what we call strip off. It wasn't ruled on in the 1992 Dusnip case, and a lot of people thought, well, maybe you can because it's different. We're not trying to strip down, we're trying to strip off. And for many years, certain courts allowed that. It was possible, and it became a very big issue after the 2008 mortgage crisis because now we have the situation where a lot of people have second mortgages, but their first mortgage has a greater amount than even the value of their home. And so then the question was, could we get rid of the second mortgage? There was a 2015 United States Supreme Court case, Bank of America v. Calumet. It's most commonly just called Calumet. Unfortunately, they went back, they looked at the language of Dusnip from 92, they applied the same ruling, and they determined that in a Chapter 7, you still could not strip off the second mortgage. Well, could you do that in a Chapter 13? Yes. You could do it in a Chapter 11? Yes. So as we've already identified, first off, if you have a second mortgage and it's giving you trouble, your options in a Chapter 7 are to get rid of the home altogether or accept that you're still going to have to pay on that second mortgage. We can't get rid of it. But if you did a Chapter 13, if it's partially secured, you could reduce how much you're paying on that. If it's fully secured, or unsecured, I apologize, if it has no value at all, you could get rid of it altogether at the conclusion of your Chapter 13 plan, and you could do the same thing in a Chapter 11. So now let's turn our attention to the issue of your first mortgage. Can you change that? Could you modify it? What if it's upside down, or as we also said, sometimes called underwater? In a Chapter 7, you're probably going to guess that the answer is no. Chapter 7 does not have a plan. The Chapter 7 is not going to be reorganizing. And so the Chapter 7 is not going to alter the relationship with the mortgage lender. It's going to remain intact. First mortgage, second mortgage, third, 48th, just whatever you have, those are going to stay in existence after the Chapter 7 case. In a Chapter 13, you cannot alter, you can't cram down the first mortgage on a primary residence. So if your home, the one you reside in, has a mortgage and you don't like the deal, unfortunately, we're still going to be using that and have to continue that obligation to keep the house in a Chapter 13 bankruptcy. What about non-primary residence? What about if you've got investment properties? What if you have other secondary homes and you want to keep those in a Chapter 13 and somehow you're able to do so? You would be able to cram those down if they apply. So again, this isn't going to really benefit you if you have equity in the house. If the home is worth $250,000 and you owe less, there's no need to modify that relationship. We're not cramming anything down. But if you have a house, you want to keep that, and it's not your primary residence, and it's underwater, so you owe $300,000 on a $250,000 loan, we could modify that in a Chapter 13 plan of reorganization, tentatively. Depends on the whole complexity of that case, but it's permissive. What about in a Chapter 11 for an individual? These restrictions on primary residences, primary mortgage, do not exist in Chapter 11. So if you have a house, now we're going to make up some big numbers. It has a value of $1 million, but you owe 1.2 on it on a primary mortgage. In a Chapter 11 bankruptcy, you could strip that down, or what we call cram down, the value, and make a better situation out of that if you wanted to retain that property as part of your Chapter 11 reorganization. So let's sort of rehash some of these things, because again, the episode name is HELOC Hell, or Home Equity Line of Credit Hell. If you have a second mortgage, the broad implications of this episode are you're either going to get rid of that house, or if you file a Chapter 7, you're going to be stuck with those mortgages. You cannot strip down, you cannot strip off. We would normally advise using Chapter 13 in those situations because of the greater power of the plan of reorganization. So with that, let's then continue talking about some of these complexities of contracts, of notes. When we have secured obligations, what can we do in bankruptcy? We're going to sort of shift gears. We're going to talk about another topic for the remainder of today's show, and that is known as cross-collateralization. That's a mouthful. What is cross-collateralization? Well, typically, in the majority of situations, when we go out and we buy things where we're borrowing money, there's two different names for that. There's what's known as purchase money security interest and non-purchase money security interest, or PMSI and PMSI. What the heck is that? Purchase money security interest is when you borrow money and the money you borrow was used to purchase the same collateral for the loan. So a house is a purchase money security interest. A car is almost always a purchase money security interest. A non-purchase money security interest is when the collateral is usually something you already had, you pledge that for the loan, there's a lien against it, and the money you receive, you borrow, is not used to purchase the collateral. So a second mortgage, like a HELOC, is a non-purchase money security interest. Well, in purchase money security interest situations, or even in non-purchase money, but typically we're going to talk purchase money security interest. You have a one-to-one relationship. If you have the loan on a car, those are tied together. So if you default on that loan, the creditor, the lender, has the right to take back the car. They could follow state law procedure under the UCC and they can repossess the vehicle, or maybe you voluntarily surrendered it on your own at some point. So let's now keep working towards this big idea of what is cross-collateralization. You now have multiple loans with the same lender. Let's say that you walk into a bank and you have 2 car loans. Without cross-collateralization, the loans are separate and the collateral is separate. So if you go into Bank of Oklahoma, you get a loan for a Ford F-150. And the next day you go in and you get a loan and you buy a Ford Mustang. At some point, you're not able to make the payments on the F-150, but you're able to take the Mustang. The lender could repossess the F-150 that we didn't make payments on, that we were in default. But they don't have the right to touch or take the Mustang under that contract if we're not in default. We have made our payments. We've done what we need to do. Even though those financial relationships are with the same lender, the contracts are what matter. The contracts are what are determinative. And so if they don't have anything tying them together, they're not going to be tied together. So what is this weird, crazy thing called cross-collateralization? Well, it's as it sounds. It is going to mean that we take the collateral and it's crossing between these different loans, between these different obligations. So whereas we'd separated before the Ford truck and the Ford car and the loan on the truck and the loan on the car, now you can think of them as put together in the same pile. That usually the language of these contracts say that any collateral, any lien, any security interest pledged to that lender in any other agreement will also be applicable in this agreement, and anything in this agreement is applicable to all other agreements. So it makes a big spider web, if you will. The purpose for the lender is very clear. The rationale is obvious, that they get greater protection because now the Ford Mustang and the Ford F-150 are collateral on both loans, and both loans apply to each piece of property. So let's use some real-world numbers to make this easy, especially for our listeners. We have a $25,000 loan on a $50,000 truck. We also have a $25,000 loan on a $10,000 car. So one has equity, one's upside down. Well, that means without cross-collateralization, if we surrendered the Mustang and it sells for $10,000 and we owe $25,000, the lender would still be stuck with losing $15,000. Now, they might be able to obtain a money judgment. We call that a deficiency balance, and maybe they attempt to collect from you, the borrower, through garnishments or other things. But you could file bankruptcy, and yet you could also still keep the truck that had equity tentatively. So they had one bad deal and one good deal, and they took a loss on the bad deal. We got to keep the $25,000 loan on the $50,000 truck. We got to get rid of the $25,000 loan on the $10,000 car. But with cross-collateralization, what it would make it is that we owe a total of $50,000 because we had a $25,000 loan on the truck and we had a $25,000 loan on the car. So now we owe $50,000 against $60,000 in property, in collateral, because we have the Mustang for $10,000 and the truck at $50,000. So you can lump them together, which means that if we give up the Mustang and we still owe that money on the car, they're going to apply the money we owe on the car to the truck. And instead of having $25,000 in equity in the truck, we just lost all that with that cross-collateralization. It's not to say that it's not right or not fair. It's business. It's a contract. It's legal, and they've got it. but we discuss it on our show because you need to be aware it exists. It's most commonly used by smaller lending institutions, especially in Oklahoma, credit unions, because they don't have the ability to weather the losses the same as a large bank such as Bank of America, JP Morgan, Wells Fargo, although these days Wells Fargo probably doesn't have the money either since they're paying billions of dollars in fines for pretty much the criminal enterprise that they've run throughout the country for the last several years. So maybe not Wells Fargo, but everybody else. So then what do we do about it? Well, the reality is you can't necessarily do anything about it. It exists. If you find out that you have this clause in your contract, the only thing you can do is work around it or accept that if you go into bankruptcy protection, you will not have as clean of an opportunity to get rid of some debts while keeping some others. I'm going to give you a scenario that's occurred recently in our office. You have one loan. It's a just personal loan, $1,500. You didn't have to put up any new collateral on it. You thought that otherwise it might have been unsecured, $1,500 loan. You have then 3 vehicle loans, and all 4 of these loans are with the same lender. Okay, so we go into bankruptcy. We're thinking otherwise, maybe we get rid of the $1,500. We give back 2 of the vehicles. We keep 1. The only thing we have to pay on the vehicle would be the loan for that one vehicle. It's a good deal. We've got some vehicle. Let's make up something, call it a Honda Accord. We've got a Honda Accord. We owe $10,000 on it, and it's worth $20,000. Good stuff. Oh, but they have cross-collateralization. So now we're probably going to have to give up all of these vehicles because when everything's said and done, the amount we owe on that Honda is far more than the value, and they're not going to want to let us keep it. Well, friends, today we've touched on these 2 big topics. We talked about mortgages first and second in bankruptcy, and then we talked about this unique concept of cross-collateralization and what that can do. In addition, just take one more moment so that we can remember the life of Howard Williams, former founder and owner of KTLV 1220 AM, our host station. Friends, it's been a great episode. We had a few tech hiccups, but hey, we recovered. We delivered hopefully for you an informative program. We will see you next week right here on The Legal Breakdown. Have a wonderful night.